Welcome, everyone. Good morning. A little bit of housekeeping before we get started. At the end of each panel, there will be a Q&A session for 15 minutes. So for panelists, a half an hour prior to the end of the panel, we will have students hold up signs letting you know that the time before Q&A is running down. And then when the Q&A starts, the students will call on people, raise their hands, or ask questions from the live stream. And it's important that the questions get repeated into the microphone so that they get captured in the recording. So either the panelists can repeat the questions as they are heard from the audience, or a law review member will repeat them at the podium before you answer. That should be it. Let me introduce Dean Brown for opening remarks. Thank you.
Good morning, everyone, and welcome to Quinnipiac Law School. The person who just spoke to you is Garrett Borden, and he is on our law review, too modest, I think, to stop and introduce himself. But he really has put a tremendous amount of work into organizing this symposium, and so I want to thank Garrett for all of that work and just congratulate you on this. And with that, my work is done. No, the only other thing I have to say is that I want to thank the next speaker, who's Marilyn Ford. Marilyn is one of the founding faculty of our law school, absolutely a statesperson, senior statesperson on our faculty, and she is quite generously given of her time and her experience and her knowledge of the history of Texas Gulf sulfur to create this symposium. So thank you, Marilyn, and congratulations to you.
Thank you, Dean Brown. And at the end of the day, I'm going to thank all of those people who actually helped to put this together, because nothing is a one-person show. But because we're running a little late, I'm not going to take the time to do that. So what I'm going to do is I'm going to invite my dear friend, Attorney Pete Eikenberry, to join me, and we're going to sit, right? Because we're going to go down memory lane and talk a little bit about Texas Gulf sulfur, the people, the case, and what has brought us all here today. Attorney Eikenberry, will you please join me? So while he is sitting, I'm just going to give a little background of why I thought it was so important to do this. And before I do, I'd like for the daughters of David Crawford to stand up and be acknowledged. Their brother, David Crawford Sr., I believe, is live streaming. And on the live stream, we also have the Honorable Charles Stevens, who is the nephew of Claude Stevens and a lot of their family members. They are live streaming. We'll acknowledge them as well. So I'm going to start out by saying that some of you know the Texas Gulf sulfur story, and some of you do not. So Claude Stevens was the CEO in 1963, and obviously in 68 when the case was decided. And one day, not too many years ago, in 1999, I was retained by Claude Stevens, Richard Mollison, who was the chief engineer at the time of the case, and others, to represent them. So what had happened? Well, Texas Gulf sulfur was the largest producer of sulfur, and in 1981, I'm going to start after the case. In 1981, the corporate jet crashed at the White Plains Airport. And on that corporate jet were several executives, the CEO at the time, the CFO, and other executives. So after the corporate jet crash, for those of you who are business people, you know that put the company in play. So with losing the CEO, the CFO, and other top executives, the company then became a takeover target. and a French corporation by the name of Société Nationale Elf Aquitaine, which was 2/3 owned by the French government, acquired Texas Gulf. And as part of the agreement that was later worked out, there were some benefit plans that were supposed to remain in effect for the top 25 execs. Things happened, they reneged on that. I was retained by the top 25 execs. I sued Elf Aquitaine. We won the case, basically, entered into a non-disclosure agreement, the case was settled, et cetera. Subsequently, Elf Aquitaine has been acquired by Total, I believe, in a $43 billion acquisition. Now, that was my introduction to Texas Gulf Sulphur. I had read the case in law school, but I had not met the individuals until 1999 when I sued on their behalf. So now let's back up. So I'm going to back up, and I'm going to include Attorney Pete in this, okay? So we know from the facts of the case, and by the way, for those of you who are online and those of you who are in person, you have some documents if you want to look. And one of the documents that you have is something called the Answer of David Crawford, right? And I'm going to be giving my factual statement from the perspective of the answer of David Crawford and from what I was told over a 20-year period by Claude Stevens, by David Crawford, and by the other individuals. So we don't deny that there was some exploration. We don't deny that as a part of the exploration, a hole was dug and a piece was taken out. We don't deny that after that, some of the directors and some of the officers bought shares of stock and some got options. That's a fact. What we do deny is that the press release which was issued was false and misleading. What we also deny is that there was a reason for the SEC to bring an injunctive relief action. Why? Because everybody who bought a share of stock and everybody who got options actually surrendered their stock back to the corporation and their options before the SEC brought the action. If you look at David Crawford's answer, he'll give you the dates, right? And not only did they surrender it back, but the board passed a resolution congratulating each and every one of them for returning every share of stock and all the options. And I think the Crawford daughters here can attest to the fact that their dad didn't get one dime out of that, right? So, and the SEC was so notified, but the SEC pursued it with the action anyway. Having said that, I have Attorney Pete sitting next to me, who was an attorney who actually worked on the case, right? So, May, it's okay if I call you Pete?
I hope so.
Okay.
I'm working for decades to make sure everybody can.
Okay. So you were on the legal team. Can you just tell us a little bit, when did you start your period of service at White and Case?
I graduated on December 24th and started on January 2nd.
Okay, all right. So you were there and you were assigned to the Texas Gulf Sulphur team. So you were on the team when the SEC brought its action. Can you tell us who was on that team? How many people were on that team? What can you recall about that team that defended you defended everyone except for, well, I'll let you tell the story.
Well, originally I was the only person because I wrote the legal memos. And as when the case was brought, then they added two other young guys, Tom McGanney and Conrad Kanacki. And then there was the person in charge of the case was Orson Martin, who was president-elect of the American Bar Association.
Now, when you started, how long had you been out of law school?
Well, actually, I did research less than a year, and then when I was assigned to the team, I was out of law school less than a year and a half.
And the reason I asked that question, and I like your answer, because we have law students in this room today, and it's interesting, and I hope they understand the impact. Someone who had only been out of law school less than 2 years, you're now working on a case. Of course, I'll ask you later if you knew the case would become as famous as it, well, why don't I ask you that now? Did you know that this case would become as famous as that has become?
It became famous on the first day.
Oh, okay.
It was in the Times, in the Wall Street Journal, as I remember, every day. And it was a really big deal.
So Barron's also probably in those days, all of the...
Well, I can't say that I read Barron's.
Oh, okay, fine. Okay, fine, okay. But you did read the Wall Street Journal
I-
and the New York Times.
I read the Times, and the journal was available at the office.
Okay, I like your honesty. You weren't billing hours at that time, so you weren't reading the journal. It got a lot of press. As a member of the defense team, I know that you wrote the memo. I have your 48-page memo. Did you actually have the opportunity to interview some of the defendants? And if so, where?
Well, I was assigned to interview practically all of the defendants, to interview all the tippees, to respond to all, when the Texas Gulf got sued by shareholders, I dealt with all the lawyers for the people that were suing. Mm-hmm. And the three-person team, Tom did the legal research after I didn't do it anymore. Conrad interviewed the experts, and I did everything else.
Okay.
And the young lawyer, the young partner who was assigned, he virtually did nothing because
Okay, I like the honesty.
every time that Orson Martin, who was the president-elect of the American Bar Association, was traveling all over the country, so every time Orson came back to town, Bill would call the three of us in and ask us what's been going on so he could tell Orson, report to Orson. So we essentially, we three guys
Ran the case.
ran the case, and we loved each other, and we played tennis together, and we stayed in touch for forever. And I spoke to Tom. Tom called me this week, and I called him back, and he's not doing too well, and Conrad died some years ago.
Okay, so I hope you enjoyed some of the backstory to the Texas Gulf Sulphur. And I'm going to be very transparent. I had a very close relationship with the then CEO, Claude Stevens, who passed in 2009. I had a very close relationship with David Crawford, who passed in 2017. I had a very close relationship with some of the others. I am not objective when it comes to this. I am very jaded when it comes to this. This really is part of a promise that I made to your dad, to Claude, and others, that we would try to have an open discussion and get their side and their perspective out. So what are we going to talk about today? Well, we have the experts here, and they are very objective, all right? We're going to talk about what is insider trading? What is the definition of insider trading? Materiality was a big issue in the case. What is effective disclosure? Because if you read what I put in your materials for today, David's answer, he was under the impression that disclosure had been made before he purchased his shares of stock. We're going to talk about those issues and anything else that the experts want to talk about as we begin our first panel. So I thank you, and I thank you for your attention as we talk about history and we go into the very first panel. All right? Thank you so much.
Speak from there.
Yeah, I think it's probably.
Thank you so much, Marilyn. My name is Donna Nagy. I am the Executive Associate Dean and a professor at the Indiana University Maurer School of Law, and it is my great honor and privilege to be moderating and participating in a discussion with my fellow panelists. And our focus is going to be on insider trading law. So I'm going to keep my introductions relatively brief. So joining us on video is Robert Fisk. Bob, can you hear us?
Yes, I can.
Excellent, excellent. So Bob is a retired partner and counsel at the law firm of Davis Polk and Wardell. And like Peter, Bob Fisk played a historical role in the Texas Gulf sulfur litigation. As Bob will explain, he and his law firm represented one of the outside directors charged by the SEC with securities fraud. Bob also played a historic role a decade later as the U.S. Attorney for the Southern District of New York when he and prosecutors in that office brought a criminal indictment in January 1978 against Vincent Chiarella, a financial printer who was convicted by a jury of insider trading, a conviction that was ultimately reversed by the Supreme Court in a decision that just about every law student in this room has read and studied or will read and study. Our other two panelists are friends and my fellow law professors, Professor Bob Thompson at the Georgetown University and Adam Pritchard at Michigan Law School. Bob and Adam have both written extensively about securities regulation in general and insider trading law in particular. They are also the authors of an outstanding new book published by Oxford University Press on the history of securities law in the Supreme Court. Now, before we launch into what I know will be a fascinating discussion, I want to offer a tribute to Harvey Pitt, who was the SEC chairman from 2001 to 2003, as well as one of the co-founders of the SEC Historical Society. Chairman Pitt passed away last May, but he had participated in the early planning sessions for this panel and would have greatly enriched today's discussion in all sorts of ways. Harvey was a staff attorney at the SEC when the Second Circuit decided the Texas Gulf sulfur case in 1968, and he was there at the SEC throughout the next decade, including for 3 years as the SEC's general counsel between 1975 and 1978. Then, in private practice, as a partner at the Fried Frank law firm, Harvey was one of the attorneys who submitted a Supreme Court amicus brief in that Chiarella financial printer case that I spoke about before. The brief was on behalf of the Securities Industry Association. Then, nearly a decade after that, in 1987, Harvey was asked by Senators Don Regal and Senator Al D'Amato to chair an ad hoc committee of securities lawyers in the private practice. That committee was tasked with developing an express statutory prohibition of insider trading. And that task force drafting efforts became what the senators introduced as the Insider Trading Prescriptions Act of 1987, which today, more than 36 years later, has been dusted off, modified a bit, and passed by the U.S. House of Representatives as the Insider Trading Prohibition Act. Now, both today's second and third panels will be talking about that proposed legislation, which remains pending in the U.S. Senate. So it will be useful to keep Harvey Pitt's role in mind as we talk about the current legislation. I know that Harvey would have made and contributed greatly to this panel, just as I know how sorely he is missed by so many attendees today, both in this room and listening to the live stream. Later in the symposium, after our lunch and before the third panel, representatives of the SEC Historical Society will be honoring Harvey and paying a tribute as well. So now, let me just take one additional minute to lay out kind of a roadmap of this first panel in terms of how we'll proceed. We've divided our presentations into 3 time periods. Bob Thompson is going to start us off, setting out for us some background history about judicial hostility to the use of common law fraud as a means of regulating securities transactions. Bob will then explore with us the changes that led to the Second Circuit's determination in 1968 that the securities trading by certain Texas Gulf officers, directors, and employees violated the federal securities laws. Bob Thompson will be involving Bob Fisk in that discussion. Second, then, I'm going to take up the baton to explore some of the events that culminated in Chiarella versus United States. Again, that printer landmark decision that entrenched the so-called classical theory of insider trading. And I'm looking forward to exploring with Bob Fisk his role in the Chiarella prosecution. Lastly, Adam Pritchett will then cap us off with his analysis of the Chiarella decision, and then Adam is going to take us through the 3 other seminal insider trading decisions issued by the Supreme Court in the 17 years that followed. The Dirks case, which involved tipper and tippy liability, the Carpenter case, which was a mail and wire fraud prosecution, and United States versus O'Hagan, which is the Supreme Court decision that endorsed the misappropriation theory of insider trading liability. Adam is also going to share with us his own role in that history, since Adam was one of the SEC attorneys who drafted the government's winning arguments in its brief in O'Hagan. So our general plan is to leave probably about 20 minutes or so at the end of time for questions from the audience. Mia's going to keep track of that. Comments by other symposium participants who we'll be hearing from later in the day. So without further ado, I'll turn things over to Professor Bob Thompson, who will begin this history.
Thanks, Donna. And thanks to Marilyn, who's had the vision to see this was worthwhile and to make it happen, and to the Quinnipiac Law School and its dean for supporting Marilyn in doing that, and for the law review that has made us feel so welcome today. This is, I don't want to say that academic conferences in law are a dime a dozen, but I do want you to appreciate how rare it is to have a case celebrated on its 55th anniversary. That does not happen very much. And I can't recall one in which such a 55th or a longer celebration has included people who were there at the beginning. And so this is, with both Pete and Bob joining us, it's an extraordinary opportunity to talk about what's happened. So why is this case worthy of this room and the people in the balcony? I don't usually get to talk to a balcony, and there are even more online, hundreds online. Why is this case worthy of our attention? And what I want to say to you is that Texas Gulf Sulphur is at the center of what was a dramatic change, one of the most dramatic changes in corporate and securities law of the last century. And it's worthy of being discussed 55 years later. I'm going to talk about the first period, what happened before Texas Gulf Sulphur, and what Texas Gulf Sulphur reflected and the change it reflected. And there's 3 takeaways that I want to highlight for you to watch for. The first is there was a history of insider trading in federal law before Texas Gulf Sulphur, but it was entirely different than what we see today. So Texas Gulf Sulphur was at the center of the most dramatic change in insider trading in American corporate law. It is so the 3 points are: first, that insider trading was around before Texas Gulf Sulphur. It had been part of federal law since 1933, since the New Deal that followed the Great Depression with a flurry of regulatory activity. But for those 3 decades, 30 years, law had avoided using the precise method that any law student today is familiar with. The law the first 30 years didn't pay a bit of attention to common law fraud as the basis for insider trading. And that's the role that Texas Gulf Sulphur precipitates by facilitating, by identifying that basic change. Second, how did that change happen at the point in time of Texas Gulf Sulphur? Well, second point is it actually started a few years before. It actually started in the early 1960s when Bill Carey went to the, President Kennedy appointed Professor Bill Carey to chair the SEC, and he had a mission, which he started in Katie Roberts, which I'll mention briefly, and then it went to the Supreme Court in a case that's called Capital Gains Research Bureau that is not as familiar to you. And that set up what happens in '68 when the Second Circuit, for the first time, applies this new thinking to an insider trading case, and that sets off what Donna and Adam will carry on when I finish. So that's the second point, that it was a dramatic change, and Texas Gulf Sulphur was in the middle of it. The third is I want to talk about how we got to that Texas Gulf Sulphur making that change. It's not the Supreme Court. It was the Second Circuit Court of Appeals, the intermediate federal court. But it was the Second Circuit was called the mother court of securities law because it decided all the key corporate cases, because the Supreme Court had not taken a federal case up until then, of insider trading case, 16B. And at the time, before Texas Gulf Sulphur, there was a very notable reluctance of the Second Circuit to buy into what Bill Carey was pushing, a reluctance of the Second Circuit to accept common law fraud as the vehicle to deal with insider trading. And you can see it in how the Second Circuit actually flipped between what they did in capital gains in 62 and 63 and what they did in Texas Gulf Sulphur in 68. So those are my three takeaways. Let me just talk about the 3 points. First one, the first federal foray into insider trading. The beginning point, pretty much, you can trace a little bit before then, was the Great Depression, and then the New Deal. But really, it was the Pecora hearings that, if students have seen that, there was a series of hearings that took place in the early part of 1933. Roosevelt had been elected with change of party, but inauguration was March the 4th. In those last 6 weeks before the inauguration, there were hearings in Washington, in Congress, that Ferdinand Pecora chaired, and insider trading was a central focus of what had led to all the bad things from the stock market crash and what had become the Great Depression. Insider trading was a repeat focus of those hearings, and so it opened the stage to what happened when Roosevelt was inaugurated on March the 4th, and immediately sent a securities bill to Congress. But what got included in Congress's action was a very clunky mechanistic weapon to deal with insider trading, Section 16B of the 1934 Act. I mean, I don't even teach it anymore. It's still around. You get lawsuits about it, but it's disappeared pretty much. But it required two trading. It required a buy and a sell by the same person with 6 months. And then you didn't have to show insider trading. You just have to disgorge any money you made on that buy and sell. The Supreme Court took 0 cases on 16B between its enactment in 1934 and the 60s. It just was not important. But the Second Circuit was busy in this space during that time. The Second Circuit had 21 16B cases in that same 30-year period, and the Supreme Court had 0. And so the Second Circuit loved to make law. It was Charles Clark, a Yale law professor, who had been appointed to the Second Circuit. He sat on 15 of those 21 16B cases, and he made the law of insider trading, but it was in this weird part that we don't talk about anymore. Charles Clark, but he framed what was going on. The Second Circuit, it was called the Mother Court of Securities because it was in New York City, the financial center. It's where all the cases arose. They came to the Southern District and then up to the Second Circuit, and the Supreme Court didn't do anything, so the Second Circuit was the final authority, and it was a close-knit court. It was like for a while it was all Coolidge appointees. If you remember Calvin Coolidge and a couple of New Deal appointees, they were close-knit. They liked doing this, like Charles Clark. This was their life. And they made a body of law across securities, but it wasn't what we know today as insider trading. And during that time, people had discussions saying, well, is there a better way to do insider trading? And can common law fraud, which is what we do now, can that be the basis for insider trading? And everyone pretty much agreed, no. Common law fraud has this set point. There's the badges of fraud you have to show. It just can't be expanded to silence with a stranger. It just wouldn't work. And so it looked like a dead end. And 3 SEC chairs went to Congress and said, no, I get questioned, can you do common law fraud? Nope, can't do it. So that's what the situation was in 1961 when John Kennedy had been elected. His father, as you may know, was the first chair of the SEC. He was aware of the SEC. He appointed a high-profile, Bill Carey was a professor of law at Columbia, ended up writing the leading casebook in corporations law. He appointed Bill Carey to be the chair, and Bill Carey came to Washington not with an agenda, Joel Seligman tells us, but he wanted to change the reluctance to use a really effective strategy, which is common law fraud, to deal with insider trading. So Bill Carey was the impetus for that, starting in the spring of 1961. In the fall of 61, Bill Carey got his avenue for change. It was a case called Katie Roberts. It was a SEC decision that was before the SEC, not before the courts. It was an injunction proceeding. The SEC they won their case. I mean, this was the staff lawyers presenting the case to the 5 commissioners. 5 commissioners said, yeah, there was insider trading going on here. And you know what the remedy was? 20-day suspension for the broker who had traded on the basis of inside information, and it was a settlement. So in other words, it wasn't what we saw with Texas Gulf Sulphur, but it introduced a new theory, which said anyone who has insider trading is doing wrong when they take advantage of it. I mean, it was written broad purpose. So this is going to change, but it wasn't the courts. But it planted the flag for what became Texas Gulf Sulphur. And the second thing that happened in that period is that the SEC was litigating. And so they took this new theory, this broad theory, this insider trading common law fraud theory, and they argued that this is what we need to do. And they argued it before the Supreme Court in Blau versus Lehman, which was being argued at the very same time in the fall of 61, the winter of 62. They argued that 16B should be infused with the purpose of the Securities Act, and it should go further than it had gone before. And this was the the Supreme Court's first 16B case. They lost. Carey made the argument, or his team made the argument. Hugo Black, writing the opinion, said the statute doesn't let you do it. Strict construction, originalist kind of statute. So what did Bill Carey do? He then went to the Second Circuit. There was a case I mentioned, Capital Gains Research Bureau. It was not a 34 Act case. It was the Advisors Act, one of the 1940 Act cases, and they took this broad approach. The insider trading should be broad. They took it, and the SEC lost it at the trial court. They lost it in the 3-judge panel of the Second Circuit hearing on appeal. They lost it in the en banc Second Circuit when they went to from the 3-judge panel. They got no traction whatsoever, and then it goes to the Supreme Court. And the Supreme Court had 2 new appointees by John Kennedy, Arthur Goldberg and Byron White. Those 2 newbies reached out to the spirit of Katie Roberts, to the spirit of purpose, to the spirit of this is, in effect, echoing the Great Depression, the solutions to it. And they said, we can use a broader interpretation of common law fraud. It was an unusual case. It involved a guy that was doing what would you call it? Well, he was trying to front run. He would put out this smart kid. I mean, he was older than that, but he wanted to put out false information, and in his newsletter, and then traded on.
It's not false.
Oh, thank you. Adam is correct to correct me. It was, but he put out information in the newsletter, and then would trade on it after running the and so the Supreme Court, with Goldberg writing the opinion, and Goldberg, his clerk described, how would you describe Goldberg's philosophy? The clerk said, well, he wanted to get things done. It was, get things done was, I think, result-oriented, but that may be my view. And so he was willing to write this broad opinion, and then Byron White made an important suggestion in writing the opinions. He said, well, you could, if you link fraud, which is what 10b-5 prohibits, if you link, and fraud is either you have an affirmative lie, or you have a half-truth, or you have omission if there's a duty to speak. Well, that was hard to have much application, particularly in an anonymous market. So White says, well, you ought to define fraud via fiduciary duty, and then Goldberg put that into the opinion, and we have what begins the flow of being able to use common law fraud to deal with insider trading on the basis of fiduciary duty, and it comes from capital gains. But that's 62, 63. It's still 5 years before we get to Texas Gulf Sulphur. So what happened with Texas Gulf Sulphur? Well, there was lots of commentary. I mean, Pete talked about how from the day the case was filed, it was famous and people were talking about it. But they've been talking about the change in insider trading for that 5 years in between. There were law review articles, there were academics that were writing about it. There just hadn't been any judicial decisions, and that's where Texas Gulf Sulphur comes in 68. It was Marilyn gave you a little bit of history, but just to give you a chronology, a short chronology. Texas Gulf Sulphur had been a sulfur company. They were now looking for other minerals. They were looking in Canada, in the Canadian Shield. In the fall of my cheat sheet for the chronology, in the fall of '63, they found some exciting results up in Canada. But they didn't own the land. So what do you need to do? Well, you need to buy the land. Well, do you want to tell the landowners that they're sitting on a no, you don't want to tell them that. So they cover up what they did, which was common in the drilling situation. They plant trees so you can't tell that they dug, and then they stop for the winter because it snows still in those days in Canada, and then over the course of the winter they buy all the land for this. And then they come back when it melts, and they do some more drilling. And then on April the 12th of '64, they put out the press release, which is arguably misleading. And that'll be the second panel can talk about that. And then, but just how the case starts. The case gets filed a year later. So April 12th is when the stock jumps, and Bill Carey goes back to Columbia in August of '64. So there's Cohen's the chair. The SEC brings the case in the spring of '65. It's still 3 years before we get the opinion. What is crucial about that period is that it goes to the trial court, and Pete was involved in that, and Bob was involved in that. The trial court rules. I understand the Crawford, not completely, but the trial court lets off. There were 12 defendants in the company or so, and lets off all but 2. So it's not a bad. It's not a path-breaking decision yet at the trial court. It then goes to the Second Circuit, and the Second Circuit you appeals to a panel of 3 judges. The 3 judges write an opinion, but they don't publish it. Then they circulate the decisions of the panel to the other. There's 9 people on the Second Circuit at the time. They distribute it to them, and then the 9 say, well, we want in on this. We want this to be decided. So we don't have the 3 judge panel decisions, but we know that the 9 then have it en banc, and then it takes them still a long time to write the opinion. And what's interesting, go back to my discussion of capital gains and the fact that the Second Circuit had, the entire Second Circuit had rejected the broad view in capital gains. What is amazing to me is that by 1968, the same judges, the same 5 judges of the 9 that had rejected any expansion in capital gains, all of them go unanimously. There's still some dissents, but not with, they go unanimously, they changed their, enough of them have changed their minds since 1962 to say that fraud can include insider trading. And there's not much discussion of it. It was a 7-2 decision at the Second Circuit, but the 2 were really angry, upset, bothered, whatever, about not the insider trading part of the opinion, but the press release part of the opinion that'll be more of a topic of the second point. What had happened in between is all the talk on the street, all the talk about theory. The Second Circuit had gotten comfortable that we could expand, they could expand 10b-5 common law fraud, and it wasn't controversial. Whereas people were apoplectic about the press release. So it's interesting that what had become accepted in just a few years of the 60s and what was still controversial, which is what you see then. So that's where we are at the opinion, and at this point I will turn it to.
Well, we were going. So
I skipped the most important part. You've already heard from Pete about what the trial was. Bob was also at the trial, so we wanted his opinion, and I apologize for almost, and Donna, keep me from letting that slip by. There were, just so the law students know, this was a big case. White & Case, big New York firm, represented the company and 10 or so of the defendants. So that's White & Case. Bob Fisk at Davis Polk represented an individual defendant, which he'll tell you about. And that's interesting, is why there was an individual, why, and that was Davis Polk. And then 2 of the others were represented by Cravath. So what you have White & Case, Davis Polk, Cravath going against the SEC. The SEC, and the way the litigation works is that the New York office handled the trial court, and the New York office, and not the lawyers in Washington. So they were up against the SEC, and the SEC brought in a fellow from San Francisco against the 3 white shoe. You know what white shoe means back in the day? Big time firms in New York. And so Pete's told you about what he did in terms of when the case was filed and how you get it together. I want to turn to Bob and ask him to talk a little bit about what he was doing at the time and what it was different because of having one client versus a group. So Bob, tell us a little bit about what you were doing.
Sure, thanks, Bob. My partner, Hazard Gillespie, and I represented Thomas Lamont, who is the great-grandfather of the Connecticut governor, Ned Lamont, who was at that time a vice president of J.P. Morgan Bank and was an outside director of Texas Gulf. The ore discovery, which precipitated the lawsuits, was announced at a press conference that started at 10 o'clock on April 16th. And they announced this enormous ore discovery. It took about 10 minutes to make the announcement. And then you could see Lamont was at the press conference, and you could see all the press media people running out to phone in the news. The press conference went on with a question and answer session for almost another hour. And at about 10:40, which is about a half an hour after everyone rushed out to phone in the news, Lamont placed a call to his friend, Longstreet Hinton, who was the head of J.P. Morgan's investment section at the bank. And Hinton had been giving Lamont sort of a hard time in a friendly way about what a dog of a stock Texas Gulf was. So Lamont somewhat gleefully called Hinton, and the conversation went almost exactly like this. He said, "Hey, Street," what he called him, "this is Tom." He said, "Take a look at the broad tape. There's some news on Texas Gulf." And Hinton said, "Is it good?" And Lamont said, "Yes." And Hinton then called the trading desk and found out that the stock was up 3 points. So without bothering to look at the broad tape, he immediately bought a large number of shares. It turns out that for whatever reason, the news didn't appear on the broad tape until 5 minutes of 11, 15 minutes after Lamont had called Hinton. And the SEC brought a charge against Lamont for illegally tipping Hinton because the news hadn't appeared yet on the broad tape. And back in those days, there wasn't any process as there is now where the SEC gives you a Wells notice and you have a chance to go down and make a presentation. I think if they had done that, we could have persuaded them never to bring this case. It never should have been brought. But in any event, it was brought. It sent shockwaves through the financial industry. It was devastating to Lamont personally, headlines charging him with fraud. And so we undertook his defense. And one of the first things we did, we called the Dow Jones reporter, a guy named Jerry Bishop. And he testified, he left the press conference at 10 minutes after 10, called the news in, and that he would have expected ordinarily that the news would be on the broad tape in less than 10 minutes after that. So we argued, I think quite persuasively, that Lamont had acted in complete good faith. He obviously believed the news was already on the broad tape because he said to Hinton, "Take a look at the broad tape." He acted in good faith. He had no element of fraud, element of scienter, which is required. And we argued that he shouldn't be a victim of the fact that the Dow Jones Instant News Service hadn't lived up to its name. I think the SEC understood that that was a powerful argument because right before the trial, they changed their position. Previously, they said news becomes public when it's on the broad tape. They suddenly changed that and said it really doesn't become public until some undefined time later when the investing public has had an opportunity to evaluate the news. Well, we had kind of a field day with that. One analyst said it would take months before you could really truly analyze the result. And so when Judge Bonsall asked the SEC lawyer, "When do you think Lamont would have been able to trade?" he said, "Well, you know, it's really impossible to formulate a rigid set of rules." So we argued to the judge that the SEC was in effect turning their rulemaking authority over to the judge, to the court, and asking the court to formulate a rule which would then be applied retroactively to cover a period of time when the rule was unknown to the people who would have had to been acting knowingly to violate it. And so in the end, Judge Bonsall ruled and completely exonerated Lamont. He also exonerated at the same time another outside director, Francis Coates, who had bought his stock immediately at the time of the announcement. So the case went up to the Second Circuit, and as Bob said earlier, they reversed a lot of what Judge Bonsall did. And they reversed the conviction of Coates. In the meantime, unfortunately, Thomas Lamont had passed away, so his case was not directly heard by the court. But in reversing Coates' dismissal, the Second Circuit said that Coates should have waited at least until it could have been reasonably expected that the news would have been on the broad tape. So in effect, the Second Circuit affirmed the exoneration of Thomas Lamont. And I think that just to go back again, this case never should have been brought. Here was somebody that actually was acting in complete good faith. He said to him, take a look at the broad tape, thinking it was already public, which was reasonable since Bishop had said it ordinarily it would be on the broad tape within 10 minutes. And if we'd had an opportunity to make that point to the SEC before they brought the case, I can't believe they would have brought it. But I think now, of course, you have that opportunity under the Wells Commission procedure, which is a great step forward for the SEC to allow that process to go forward. But that's the story of Thomas Lamont.
Well, but one side effect of that, Bob, is that you didn't get to participate in the arguments before the appellate court. So
No.
did you have any? So my question is, did you have any involvement after that at all? But more importantly, look, you were deeply involved. Did you have a sense that this was coming? Did you have a? I mean,
No.
the district court had for the group as a whole was open, sympathetic to the defendants. I mean, you know, a lot of people, the company, but the Second Circuit is a pretty dramatic reversal. Did you see that it was going to be a much tougher? If you had continued going on into the Second Circuit, do you think it would have been as easy as you had at the trial court?
Well, I think, you know, of course, we were representing Thomas. We'd actually written our brief to the Second Circuit. So the issue was fully briefed for the Second Circuit. And then unfortunately, Mr. Lamont passed away before the argument. But I am confident we would have won in the Second Circuit because when they reversed the dismissal of Coates, they said Coates should not have bought immediately upon the announcement. He should have waited at least until it could reasonably have been expected that the news would have been on the broad tape, which is exactly what Lamont did. So I'm 100% sure that if Mr. Lamont had survived for us to make that argument to the Second Circuit, we would have won there as well.
Well, thanks so much, Bob Fisk and Bob Thompson, for that first part of our discussion. We'll be hearing from Bob Fisk a little bit later when I talk about the Chiarella case, because he went from being a defense counsel at Davis Polk to being the U.S. Attorney for the Southern District in New York in 1976. Before I take the baton, then, I'm just going to ask Adam Pritchard whether he has any sort of brief commentary to give us before we start in the next phase of our history.
So I threatened Donna with a rant, and I'll try and be brief.
Short rant.
Short rant. This is a bad decision and a terrible opinion. And those are two different things. The opinion is a bad opinion because it fails at basic legal reasoning. It does not derive neutral principles from sources outside the judge. It invokes essentially one principle that resolves all of the issues, which is that the securities laws were intended for the protection of investors, which leads us to the conclusion that the SEC should win. The limiting principle of the purpose of the law is to protect investors is difficult for me to comprehend. This is poor reasoning because Congress didn't enact a purpose. Congress enacted a law that granted authority to the SEC in certain situations, outlawed certain things outright without any further action by the SEC. But the provision at issue, Rule 10b-5, is adopted pursuant to Section 10b, which prohibits nothing. Section 10b authorizes the SEC to prohibit manipulative devices. The SEC took up that authority to fill what was pretty clearly a hole in the securities laws. Section 17 of the Securities Act prohibits fraud in the sale of securities, but not the purchase. Some insider of a Boston company was going around bad-mouthing his company and then buying up the shares, and the SEC said, we should do something about that. And they did something by making fraud in the purchase of securities also illegal. But there's no departure from the ordinary standards of common law fraud at that point, right? Lying about the asset and then purchasing it is fraud under the common law. This is just giving the SEC the regulatory authority to pursue it. This seems like an entirely legitimate use of the SEC's authority under Section 10b. And then the SEC stopped. They stopped adopting rules under Section 10b and instead decided that they would use Rule 10b-5 as the general tool to fix whatever perceived evil they saw in the securities markets. And this is where we get to a bad opinion, right? This is a terrible decision and a bad opinion because it is a complete distortion of the common law of fraud. It is awkward to shift from the common law of fraud, which requires the plaintiff to show reliance and damages, to a government regulatory provision where the government is trying to prevent fraud, punish it when it happens. And that translation of reliance into that authority, it's a little awkward, right? Because the SEC doesn't rely on the misstatements. But the effect of the Texas Gulf Sulphur decision is to eliminate the reliance requirement from the law of fraud under the federal securities laws. And it does it in two ways. The first is by creating a prohibition against non-disclosure in exchange transactions, where the person on the other side of the transaction is not relying on the insider with whom they are trading. Why are they not relying? They don't know who it is. They have made a choice. The second thing that the decision does in terminating the law of reliance is the reasonably calculated to influence the investing public. So this sets the stage for the elimination of reliance in standard private claims, which the panel will talk about more after us. But passive price takers are allowed to pursue claims under 10b-5 without a showing of reliance. And in both cases, we have people who have not invested in information, and it's completely severed from the law of fraud that Congress adopted in 1933 and 1934. This could have been solved if the SEC had adopted a rule saying that insiders would have to give up secret profits if they purchased and sold securities on the basis of information that was non-public. This could have been solved if we had said that defendants had to purchase or sell securities in order to be liable under 10b-5 under the in connection with clause. And everything that is wrong with securities law would have stopped if TGS had been properly decided. That was short, Donna.
Well, I appreciate, Adam, the efforts that you made to shorten that rant. So my take is a little different, not surprising. But I'll start by highlighting again what many consider to be the Second Circuit's broad holding in Texas Gulf Sulphur vis-a-vis insider trading, at least, namely the en banc statement that anyone in possession of material inside information must either disclose it to the investing public or must abstain from trading in or recommending such securities. So in class, we teach that as Texas Gulf Sulphur's disclose or abstain rule. Some folks regard this as a parity of information rule. The fact is, though, that what the Second Circuit held is actually subject to considerable debate. To be sure, the Second Circuit used the term anyone in possession. And anyone means, well, anyone. Certainly, anyone includes officers, directors, and employees of the securities issuers. But the term anyone draws in many others. So if we take from the Texas Gulf Sulphur opinion, TGS opinion, that single sentence, and if we mesmerize and focus on that single sentence, we would extract a very broad insider trading prohibition. Anyone would mean that a person who merely overheard employees at TGS talking about the ore strike, the person who overhears that couldn't trade on the basis of that information. Anyone would also mean that someone who keeps diligent track of property records and learns that Texas Gulf is buying huge parcels of land in Canada might be precluded from trading on that information. So, did the Second Circuit truly mean anyone who has mere possession? At an earlier point in the opinion, the Supreme Court also, the Second Circuit also quoted the SEC's opinion in Caddy Roberts, which grounded the disclose or abstain rule in a somewhat narrower policy concern having to do with the access to information. Earlier in the opinion, Judge Waterman talks about the justifiable expectation of the securities marketplace that all investors in impersonal exchanges have relatively equal access to material information. And if access is what defines the duty to disclose, then the person who simply overhears Texas Gulf Sulphur's executives may well be able to legally trade on that information, even though it may be deemed, and indeed is, inside information, because the person who overhears that knowledge was not by virtue of any privileged access or any structural asset. And since both quotes, the anyone quote and the relatively equal access quote, come from the same Judge Waterman's opinion, it's tough to say which was the key statement. In an influential law review article written in 1968, shortly after the opinion, then Professor David Rudder doubted strongly that Judge Waterman was seeking to adopt a mere possession test. And David Rudder later went on to lead the SEC as chair, later co-founded with Harvey Pitt and Paul Gonson the SEC Historical Society. Many years after that, Professor Don Langevord, who we'll be hearing from in the afternoon, in his critique of the Texas Gulf Sulphur decision, likewise sets out reasons why this anyone and possession language could rightly be regarded as dicta. And so we're going to be hearing from Don a bit later, but I think we all have him to thank for drawing much attention to what the Securities and Exchange Commission as an agency was saying, and what the SEC as an agency was doing in the wake of and in the years following the Texas Gulf decision. And so I point you all to Don's 2018 article, which was published in the SMU Law Review, entitled From Texas Gulf Sulphur to Chiarella, A Tale of Two Duties. So Don's article points out, for example, that in the SEC's enforcement action against Investors Management Company, which was a firm that received inside information from Merrill Lynch about an unexpected decline in Douglas Aircraft's earnings, the SEC actually drew more from the Caddy Roberts commission decision that Bob Thompson talked to us about than it did from the Texas Gulf Sulphur decision. Commissioner Roberts' concurrence in investment management also dials way back the mere possession language and links tippee liability to the tippie's after-the-fact participation in an insider's breach of duty owed to the corporation. not to disclose or use the information for a non-corporate purpose. And so you can trace Commissioner Roberts's concurrence there into the Justice Powell position that Adam will be talking about in the Dirks case. Commissioner Smith also observed that purloined information, misappropriated information, would satisfy his test, not necessarily Justice Powell's years later. Commissioner Smith analogized the use of wrongfully obtained information with knowingly accepting and using stolen goods. While all this was going on in the 1970s, there were also calls for the codification of an express prohibition of insider trading, which then would have been part of the Federal Securities Code, which Harvard law professor Louis Loss was a principal drafter. The prohibition in the code, for the most part, would have defined the terms insider to include officers, directors, and employees of the securities issuer whose stock was trading, along with agents working for the issuer and knowing tippees. But the Federal Securities Code, again, never enacted by Congress, certainly didn't go as far as anyone in mere possession. So now we're to the part of our Chiarella history, and one that was explored in depth at another SEC Historical Society Symposium in November 2020, sponsored by NYU Law, as well as my own Indiana University Maurer School of Law. So I've written a law review article setting out the rich history of the Chiarella litigation. And back years ago, I had the great pleasure of interviewing Bob Fisk in connection with that project. So I'll be turning to Bob on our video in 1 minute or so. But let me say a few words about the facts of the Chiarella case. I said it's very well known, but the facts are also really simple and easy. Chiarella was a financial printer who worked for Pandic Press, a printer that had been retained by the acquiring firms who were planning to announce confidential takeovers. Of course, when it was announced, it wouldn't be confidential, of targets. The target companies were all given code names, but the somewhat ingenious Vincent Chiarella managed to deduce the identity. He was actually very talented at Sudoku-type crossword puzzles, and purchased stock after having deduced the code names in the targets in advance of the tender offer. So the SEC files a civil enforcement action against Chiarella in 1977. The SEC charges Chiarella with violating Section 10B and Rule 10b-5, the anti-fraud provisions of the federal securities laws. Chiarella and the SEC settled the case in May 1977 when Chiarella consents to an injunction and agrees to disgorge his ill-gotten gain of $30,000. So one of the things that interested me about researching the history of the Chiarella case is how does an SEC settlement for $30,000 morph into what becomes the landmark Supreme Court case on insider trading, or at least at the time. So the settlement was reported in the New York Times and the Wall Street Journal, and I believe soon after, the fraud unit in the U.S. Attorney's Office in the Southern District of New York began contemplating the possibility of proceeding with a criminal case. So Bob Fisk was the U.S. Attorney in the Southern District of New York at the time. Bob became U.S. Attorney in 1976. So I have a few questions for you, Bob. I want to hear about the Chiarella prosecution and the decision leading to the Chiarella prosecution for sure. But let me ask you first about the years prior to Chiarella's indictment by your office in 1978. Were there discussions with prosecutors in your office about the possibility of pursuing a criminal case for insider trading? Discussions that preceded the Chiarella indictment?
Yes, there were. we had conversations that the then chief of the fraud unit was a man named Rusty Wing, who was then succeeded by now Judge Jed Rakoff. And the three of us did have discussions that we thought when an appropriate case came along, it would be good to commence what would have been then the first criminal prosecution for insider trading. So we definitely had a potential prosecution in mind, yes.
So what was it about the SEC settlement in the Chiarella civil litigation that caught the eye of the Southern District of New York, thinking that now is the time to indict what would be the first criminal defendant for the crime of insider trading under the federal securities laws?
Well, the reason was there'd been a history of settlements by insider trading by printers at different printing companies in New York. There was a settlement with a printer from Sorg, which got a lot of publicity. And again, it was the same kind of, we don't admit or deny, but we'll agree to an injunction and disgorge the profits. That got a lot of publicity. And then a lot of the printing companies, including Pandic, took steps to make sure that their printers were not engaging in insider trading. And at Pandic, there was a very large sign that basically told the printers, you are not allowed to engage in insider trading. You can't act on any of the information that you receive. If you do, you'll be subject to civil and criminal penalties, including 5 years in jail. Notwithstanding that, there were 3 or 4 more other settlements with printers at printing companies. So by the time Chiarella came along, there had been at least 4. And we came to the conclusion that this isn't working. You know, these SEC consent decrees where they give the money back isn't serving as a deterrent to printers doing this. So it's time to up the ante. And in particularly in light of the fact that we thought Chiarella had been warned repeatedly not to do this in signs that he had to look at every day when he checked into the office, we thought this was an appropriate time to do something that we hope would be a bigger deterrent than just these SEC consent decrees.
Yeah, so a couple of thoughts on Bob Fiss's recollection there. I mean, one, it's important to remember, and it's implicit in what Bob Fiss just told us, that in the late 70s, the SEC's enforcement remedies were an injunction and disgorgement. And actually, the disgorgement links right back to the Texas Gulf Sulphur case, because it was actually the judge, the district judge in Texas Gulf Sulphur, asked by the Securities and Exchange Commission to use his equitable powers to instruct, to order the defendants, then found liable after the Second Circuit's decision, to give up, to disgorge their ill-gotten gains. In 1984, Congress amended the federal securities laws to provide penalty authority, to provide federal district judges on request of the Securities and Exchange Commission to penalize up to 3 times the profit made or losses avoided. But back when Bob Fisk and the prosecutors were deciding what to do with printers like Chiarella, the SEC did not have that civil enforcement authority. So give back what you unlawfully gained, and don't ever do it again, were the remedies. And so criminal law then was really the only vehicle that law enforcers had on hand, because criminal law can actually put, at the time, fining authority as well as jail time And so I think that's something to keep in mind as we think of the history. The other thing, and I want to ask Bob Fisk now about his recollections of trial and who tried the case and how all, but before I do, I can say that, having taught the Chiarella case for, probably 20 years or so, before I talked to Bob Fisk and Rusty Wing and John Sifford, who was the trial attorney, I came to a rather cynical view of picking on poor Chiarella. Why wasn't it a wealthy investment banker? Why wasn't it an insider in a company who fully recognized that he or she was essentially taking stockholder information and using it for personal profit? Why wasn't that person brought up on criminal charges? Why Chiarella? And as all three pointed out to me, Chiarella had a sign in his workplace that said, "This is a crime." And at the time, law firms didn't have signs. In fact, they probably still don't, that say this is a sign. But every law firm associate and every law firm partner and every law firm clerk and photocopy person is certainly taught from their first day of employment that insider trading is a crime. But printers actually had full notice of that. And I must say that really changed my view in terms of the justice and the fairness of naming a defendant like Chiarella. So, Bob Fisk, if you could talk to us about the indictment, the decision leading up to the indictment. You've explained why. The trial, the conversations you may have had with John Sifford, who was the trial attorney.
Well, I don't remember any specific conversations other than, I wished him well. I watched part of the trial and I was, very pleased when we got a conviction. And incidentally, Chiarella took the stand and testified and said he didn't think he was doing anything wrong. And he said he never saw the sign. He never read the sign. And I think John demonstrated that he had to punch in the morning, and the sign was right above where he punched in, and he punched in 697 times before he engaged in this trading. And so the Judge Owen found that was perjury, not surprisingly.
Yeah. And that fact actually makes it into the Second Circuit opinion in the Chiarella litigation, the number of times. And John Sifford's cross-examination of Chiarella is masterful. And really for anyone taking trial practice, if one could get the transcript of that, it really is quite. The other masterful attorney in the Chiarella litigation is on the defense side. Chiarella hired Stanley Arkin to represent him after he was indicted. And so Stanley Arkin represented Chiarella at trial before the Second Circuit on appeal. And then Stan Arkin successfully petitioned the Supreme Court for certiorari and convinced the Supreme Court 6-3 to reverse Chiarella's conviction. So let me talk a little bit about the Chiarella District Court and Second Circuit opinion. Judge Owen, who was the district court judge in Chiarella, refused to dismiss Bob Fisk's and Rusty Wing's and John Sifford's indictment. Stan Arkin motioned for dismissal of the indictment. Judge Owen refused to because Judge Owen ruled that it stated a claim for both fraud on the target shareholders, and so the government had framed the case as an equal access to information, and Chiarella had privileged access as the printer who printed these documents. Judge Owen also interestingly found for purposes of this motion, that the government has stated a claim for a fraud against the acquiring companies whose confidential information had been essentially embezzled for securities trading purposes. And so Judge Owen basically also found the government has stated a claim for fraud on the source of the misappropriation, source of the misappropriation of the information. So sort of precursor to the misappropriation theory. Stan Arkin took the position, and Judge Owen seemed to agree later in the trial, that the government had not adequately charged the misappropriation of the information in order to constitute a fraud on the printing company and the clients. So Judge Owen wouldn't let that charge go to the jury. That was not part of the jury instructions. So Bob Fisk, you said you attended the trial. Was there anything, or attended a portion of the trial? Was there anything memorable that you'd like to share with us?
No, well, I don't, I think I attended for part of the trial. I attended the opening statement.
Okay.
Which, and I attended the summation, and I think I attended part of the Chiarella cross, including where he denied that he'd ever read the sign.
Interesting. So the jury voted to convict Chiarella for securities fraud on every count. Judge Owen sentenced Chiarella to 1 month in prison and 5 years of probation. So the Second Circuit hears Chiarella's appeal in October 1978, and the panel votes 2-1 to affirm the conviction. And so round 2, Bob Fisk in the U.S. Attorney's Office wins. Judge Kaufman's majority opinion, so I said it was a 2-1 opinion, stepped away from the broader equal access theory of Rule 10b-5 disclosure and replaced it with a more limited obligation applicable to only those who regularly received market-sensitive information. So see where we're going. There's the Texas Gulf Sulphur, anyone in mere possession, which is arguably dicta, to a government theory in the Chiarella case about equal access, to a Second Circuit decision in Chiarella with this disclose and abstain rule applying to only those who regularly receive market-sensitive information. So Stan Arkin, the masterful defense attorney, then petitions for cert. And his cert question, it's quite interesting to look at the actual wording of the cert petition. I'll read it. Does the purchase of stock in the open market does the purchaser of stock in the open market who fails to disclose material non-public information about the issuer of the stock violate Section 10b, Rule 10b-5, when the purchaser has no fiduciary relationship with the issuer? Stan Arkin frames the cert question to specifically focus on fiduciary duty. And his whole the whole theory of the defense is a narrower reading of the Texas Gulf Sulphur case, which is that only insiders have this fiduciary duty to disclose to the persons on the other side of the transaction. He writes a 20-page cert petition. So the Solicitor General's opposition to the cert was 7 pages. It was the Solicitor General Wade McCree was the Solicitor General. The cert opposition actually fails to quote Judge Kaufman's regularly receipt holding. That's nowhere in the opposition to cert. Instead, and perhaps ironically, and very notably for purposes of this symposium, the Solicitor General's brief in opposition to cert harkens back and quotes instead to the language from the Texas Gulf Sulphur case, which was not the case that was being petitioned for cert this time around. And so there's several interesting, it's a short opposition. It doesn't quote the relevant language in the Second Circuit's Chiarella holding. And had it done so, perhaps the Supreme Court might not have even granted cert in that case. But the Supreme Court did grant cert. So the Supreme Court grants the cert petition in May 1979, and the government was being represented by the Solicitor General's office as it is. So it's now the Second Circuit folks are no longer in charge of the litigation. The Southern District of New York U.S. Attorney's Office is no longer in charge of the litigation. From the SEC Historical Society's oral history of Judge Frank Easterbrook, who was then Deputy Solicitor General, Frank Easterbrook, we know how the Solicitor General's office kind of turned the argument. He raised objections to what he had viewed as the government's equal access approach to Rule 10b-5 insider trading liability. And then Deputy Solicitor General Easterbrook wasn't a big fan of the Second Circuit's regular receipt language either. Instead, the office opted to go sort of all the way or go all in with a misappropriation approach. Assistant Solicitor General Stephen Shapiro and the SEC's Paul Gonson worked together to reframe the arguments to center on two misappropriation themes: that Chiarella violated Rule 10b-5 by defrauding both the acquiring corporation, whose information he had converted, as well as the investors who sold their shares in the target companies without that informational advantage that had been wrongfully misappropriated. So the case was argued to the U.S. Supreme Court under this sort of new theory on November 5th, 1979. The oral arguments on both sides were masterful. Stanley Arkin argued for Chiarella as the petitioner, and Stephen Shapiro argued for the government. Paul Gonson as the SEC's solicitor, and John Siffert from Bob Fisk's office in the Southern District of New York sat with him at the table. And so, Bob, I'll give you the sort of last question before we turn this over to Adam to continue our history. So, Bob, did you continue to follow, Bob Fisk, did you continue to follow the Chiarella case then as it was at the Supreme Court, even though it was being argued by the Solicitor General's office?
Well, I obviously had an interest in the outcome, but I don't remember having an opportunity to review the opposition to the petition for certiorari, and I don't think we were consulted on the theories that the Solicitor General was advancing.
Mm-hmm. Yeah, and so it was litigated under very different theories for sure than you and Rusty Wing and actually Jed Rakoff became the principal deputy in your office then as it was going on then to the Second Circuit. And so it did become a different, very misappropriation, obviously, focused case. And so Stan Arkin was successful in convincing 6 of those justices to vote in favor of reversing Chiarella's conviction. And so the sort of misappropriation focus, Chief Justice Berger agreed, but others on the court felt that it hadn't been adequately presented to the jury, and therefore this was not the case to be making law on a misappropriation theory. So that had to wait for another day. The Vincent Chiarella ultimately was successful in convincing the 6 justices. The court announced its decision on March 18th, 1980. Bob, at that point, were you still U.S. attorney, or was that just as you were packing up your office?
I left on March 1.
Okay. So that's, well, so there we have it. I'm going to turn this over to Adam in a minute to discuss the Chiarella decision and the sort of aftermath of that. But I want to first, well, first I'll give Bob Fisk any last words that you might have.
No, I think you've covered it very well, Donna.
What? So when the Supreme Court then announced a decision that ultimately then exonerated Chiarella, do you recall your reaction? You would have been back at Davis Polk at that time then.
Yeah, I'm sure I was disappointed in the result.
I would imagine after the years that the office had spent there.
And we used to say somewhat facetiously, but not entirely facetiously, we won the case and the Solicitor General lost it.
Well, what a way to end this part of the history there. Let me ask Bob Thompson whether he has any comments he wishes to.
I'll let Adam.
Okay, Adam, take it. Thank you very much, Bob Fisk.
That was the perfect segue from Bob Fisk. Winning a case in the Supreme Court involves counting to 5. And so Frank Easterbrook made a calculation that the Second Circuit's theory of insider trading was unsupportable in the Supreme Court, and that he could not get to 5 on a theory that involved having access to information creating a duty. He made another calculation, which was that the fact that the alternative misappropriation theory that he thought was defensible, the fact that it had not been presented to the jury. I asked him about this at a conference. He said, I thought we might get away with it, which was refreshingly candid. And there was, comments from the prosecutor and maybe some discussion that it was there, but it was definitely not in the jury instructions. And that turned out to be the fatal flaw. And so the case comes to Justice Powell, and Easterbrook had made his calculation about what he could get to 5 on based on a very different court in 1980 than the 1964 court that had decided capital gains. Justice Powell was now the court's leading figure in the field of securities law. He had been on the court for 8 years, and it was very clear that he was the dominant justice in this space. There had been a Wall Street Journal story earlier in the year about Powell's influence on the securities law and how that was a bad thing for the SEC because they kept losing cases. And it happened again in Chiarella. So the case goes to the Supreme Court. Powell reads the cert memo. His clerk notes the qualifier in the Second Circuit opinion about regularly receives confidential information, and there's a question mark put by Justice Powell in the margin next to regularly, and a question mark in the memo says Powell's not buying it, right? And so the bench memo for the case that Justice Powell received did not discuss the jury instructions failure to include source. There was discussion about the jury instructions on whether Chiarella had the requisite intent, but this duty to the source question was not there. So the justices hear argument, they go back to conference. Justice Rehnquist says, CA2's decision is outrageous. It held there was fraud in the air, so somebody should go to jail. This is how they talk at conference. You have to translate that into an opinion, but that is the zeitgeist among the 9 when they are deciding the case. But at the end of the conference, the junior justice, John Paul Stevens, raises this jury instruction point. And this is the first anyone has thought about it among the 9. Powell goes back and tells his law clerks, check the records, see what the jury instructions said, and nope, jury instructions are basically a parody of information. If you've got information, you're required to disclose it. The fraud on the source was not in the jury instructions. Justice Powell writes to Justices White, Stewart, and Rehnquist, says, I can't get to 5 on a narrow theory of fiduciary duty. We're going to have to decide this on the jury instructions. White, Stewart, and Rehnquist would have been there to reject the Second Circuit's approach on equal access very broadly, and also reject the misappropriation theory at that time. Stevens wants to say, I'm not going to decide the misappropriation theory until it's properly presented. So Powell writes the decision narrowly, emphasizes that fraud requires a duty of disclosure, and includes in this between the parties to the transaction, which turns out to be quite important. But the holding is this broader theory of misappropriation was not presented to the jury. You can't convict someone on a theory that was not presented to the jury. All right? Powell wrote this narrowly, not because he necessarily believed in this as the correct rule, that there needed to be a duty between the parties to the transaction, but that the SEC should not be allowed to do this through the course of litigation. That if the SEC wanted a broader rule, there was an institution that could help them with that. It was called Congress. And there's a letter that Powell sends to Berger saying, I agree with you, Chiarella is a bad man. I don't admire him any more than you do. But the answer to this problem in the securities markets is for Congress to pass a law. So, with the aftermath, the SEC, this is a loss, but it could have been worse, I guess. And Don has written about this and was a party to it. The General Counsel's office drafts a rule that would have essentially codified the misappropriation theory. There is another rule that was already in the hopper that prohibited broadly trading on inside information in connection with tender offers under a different source of legislative authority in Section 14E, which gave the SEC definitional authority, and it would be much easier to defend than a broader rule under Section 10B, which might have been easy to defend in 1961 when Bill Carey went on his agenda against insider trading. But after Chiarella, you've narrowed the space available under Section 10B. The Commission ultimately decides to take the easy path, adopting Section 14E3, and puts off for another day trying to worry about what the contours of the insider trading prohibition would be under Section 10B. The Southern District of New York says, okay, Justice Berger, thank you very much. We're going to run with this misappropriation theory that was advanced, and they make a decision, a strategic decision, that Berger's broad theory of having stolen information and not disclosing it was fraudulent, and decides instead to go with a theory that not disclosing to the source of the information was fraud on the source of that information, and it would satisfy the in connection with requirement if you subsequently used that information to trade without disclosure. So, Second Circuit upholds this theory in the Newman case. Supreme Court denies certiorari. Justice Powell notes that he would have granted, but does not write separately, which he was willing to do in securities cases, but didn't think this was the time. Powell generally reaffirms the fiduciary duty-based theory in Dirks. It's kind of a repeat for him of the theory that was rejected in Chiarella. The D.C. Circuit had taken up what Powell considered to be a variant on the equal access theory that was repudiated in the Chiarella case. The Solicitor General's office refuses to defend the D.C. Circuit's judgment in the Supreme Court, and the SEC has to defend it alone, and it goes about as well as you might expect. So the government is 0 for 2 in insider trading cases now after the Dirks case. Third time's the charm? Almost. U.S. versus Carpenter is the next case to come to the Supreme Court, arising out of the Herd on the Street insider trading scandal. Foster Winans writes the Herd on the Street column, which shows up at the back end of the Wall Street Journal. If you're a deep-in junkie for financial news, you read it. It moves the market. The discussion in that column kind of predictably, if it's a positive spin, it's going to go up. If it's a negative spin, it's going to go down. Foster Winans and his co-conspirators trade on that information, knowing full well that it contradicted the Wall Street Journal's policy to use that information for personal purposes of any kind. The Second Circuit upholds the conviction of the co-conspirators. It gets to the Supreme Court. The court votes against granting certiorari. Justice Powell is in his last term on the Supreme Court, and he and Justice O'Connor and Justice Rehnquist had voted to grant cert. But on a cert grant, you got to get to 4. He writes a dissent from the denial of certiorari, which broadly rejects the misappropriation theory, says that in order for it to be fraud under 10b-5, you have to defraud the counterparty to the transaction, a very traditional notion of fraud that would be roughly consistent with a common law version. His dissent attracts the votes of Justice Brennan and Justice Scalia to grant cert. The case goes to the Supreme Court. Justice Powell retires. There is some difficulty in replacing him, so 8 justices hear the case in Carpenter. They uphold the misappropriation theory as applied through the mail-in wire fraud statutes unanimously, 8-0, but the court splits 4-4 under the securities laws. So now the Justice Department can enforce criminally the misappropriation theory. The SEC does not yet have validated the opportunity to vote it, to enforce it in a civil action. A major hole for the SEC, as they see it, in their enforcement arsenal. The Justice Department can and we can't. That's not fair. All right. So another criminal case, I'm skipping ahead because of time. The important criminal case is United States versus O'Hagan. And the Eighth Circuit repudiates the misappropriation theory. Jim O'Hagan had taken client information and traded on it in advance of a tender offer. And this is where I actually play a very small role in this history, which is Pritchard is the junior guy on the O'Hagan team for the government. He gets sent off to look at Thurgood Marshall's papers, which had recently become available to the public, and finds Justice Powell's draft dissent, which was never published, and finds out pretty much why the court had split 4-4 in the Carpenter case. So government knows what we need to do is persuade the Supreme Court that stealing information from the source of the information without disclosing is in connection with the purchase or sale of the securities. So, key argument is the failure to disclose that you're taking the information and trading on it coincides with the purchase or sale. Jim O'Hagan, if he had disclosed right before that he was going to use client information and trade on it, if he had called up Grand Met's general counsel and he had told the partners at his law firm that he was going to trade on the information, would not have been guilty of fraud under 10b-5 because he would have disclosed it. And under Santa Fe, that would have been sufficient to exonerate him. But he didn't disclose, and the instant he didn't disclose, he traded, and that violated Rule 10b-5. The Supreme Court accepts that. Justice O'Connor votes for the theory, which she had rejected back in the Carpenter case. This is complete speculation. Jim O'Hagan was a crooked lawyer and intolerable to Justice O'Connor that someone like that should be practicing law. So where's Texas Gulf sulfur? it's basically gone. The reasoning of Texas Gulf Sulphur that Justice Powell had cabined narrowly in writing the Chiarella decision, the government cites Texas Gulf Sulphur and Katie Roberts in a string cite for this is the classical theory of insider trading. This is not the source of the law. And so the decision comes down. Justice Ginsburg explains how the misappropriation theory does not conflict with the holdings in Chiarella and Dirks and serves the broad purposes of the securities laws, and good enough. Close to being kind of on time.
Excellent,
Q&A
excellent.
time.
So it is Q&A time. It is Q&A time. One point to just tack on, though, to Adam's point about the classical theory that the insiders, those who owe a fiduciary duty to the issuer and the shareholder, owe a disclosure duty in those transactions. So that's Chiarella's theory. Stan Arkin in his briefs, really. So if we sort of, as historians, if we sort of trace back, and that, Stan Arkin traced back to Texas Gulf Sulphur. That was his takeaway from the Texas Gulf Sulphur opinion, not the broad anyone language, but the officers, directors, and employees of issuers owe fiduciary duties to the persons on the other side of the transaction.
Which is consistent with the holding of Texas Gulf Sulphur.
Correct.
The reasoning is all over the map.
All over the map. So, question and answer time. So,
hello, everyone. My name is Mia. I can field questions. So I see Attorney P has a question.
That we need to get the mic. There's-
Yeah, and so I was just going to say, if the panelists could restate the question before answering, I think that would be.
So Pete's question is, so we're going back to Texas Gulf Sulphur, given that the officers and directors and employees of Texas Gulf had spent years in this litigation and certainly had taken away from the litigation that trading on the basis, or at least while in possession of material non-public information, is a violation. Why bring the case? Why enjoin these defendants from ever doing it again? Pete, do I have that question? Yeah. And does anyone else? So I think that the Second Circuit ultimately agreed with most of that takeaway, Pete, for most of the defendants, but felt that high-ranking officers of the company were in a different position. Given that they weren't relinquishing their role. On the disgorgement issue, the Second Circuit, so this Texas Gulf litigation is, I mean, if anyone sort of does the Westlaw search, there's five opinions of the SECs. Then there was all sorts of civil litigation as well, and so lots going on here. But after the Second Circuit in the Texas Gulf Sulphur case essentially reversed the trial judge findings on liability, it had to go back to the district court for the remedy stage of the litigation. And as Pete said, most of the defendants were not in a position where they could do this again or where there was a reasonable concern. The SEC, though, was also seeking disgorgement. Now, the officers of the company, Stevens, Crawford, had voluntarily, as Marilyn reminds us, forfeited, given back, sold back to the corporation at cost their stock, but the employees had not. And so the remedial phase involving the question of disgorgement involved whether the employees should be forced to give up their ill-gotten gains. And at least one of the employees was being held responsible for the ill-gotten gains of his tippees. And so that was a matter of litigation as well. So we have the disgorgement remedy is another huge part of this Texas Gulf sulfur opinion.
Any other questions? I see you have a question.
So I had a question for Mr. Fisk about the defense of Mr. Lamont. Specifically, if I understand the issue, it's sort of Mr. Lamont traded. So there's an issue as to whether material non-public information had been publicly disclosed and disseminated. And one way of approaching this issue, of course, would be to look at, was it over the tape or was it broadly disseminated? But another way that you didn't talk about, and I wanted to ask you about, if you had any thoughts on, would be looking at share prices, right? So if we have a press release and then or a press conference, and then we observe share prices adjusting, then putting aside, appearing on the Dow tape, because there are going to be people in the room who are actively listening in the press conference and things of that nature. Wouldn't that be exculpatory? And was there any effort to introduce evidence about share prices with respect to Mr. Lamont's trading or any of the other defendants, as far as you know?
He doesn't hear the question.
Yeah, so, but everyone here did. So I think actually, John, it's a great question. And so I think I can quickly rephrase that. Bob Fisk, John Macy just took us through the economics of this and basically asks the question whether, when you were representing Lamont, whether there was thought on the defense side to making an argument that the information was impounded into the stock price, essentially, so that it was public by virtue of its reflection in the stock price, as opposed to the SEC's absorption theory or reasonable dissemination theory.
Well, I think the evidence was that at the time Lamont called Hinton, Hinton checked with the trading desk and the stock was up 3 points. So obviously there were people out there that knew about the information, even though it hadn't appeared yet on the broad tape. So there was enough activity out there to raise the price of the stock, but I don't think that was enough to argue that the information was generally public at the time.
And if you look at the data, it wasn't just up 3 points by the time he traded, and it wasn't, and there was the 30s. It got to 70 within not that day or the next day or the next day. So there was still information being impounded, and the insiders could have had a sense of that.
But the information was it good or bad? Right?
I think the information was
The stock price was
the information was good over and over again.
Yeah.
That it was good.
Right, but you know how good it is. It was really, really
It was
good.
really, really good.
It was $70 good, not $30 good.
Yeah.
But that suggests it's impounded exactly on the trade, that the decision that
I would rather be on the inside and have the 70 pounds instinct than.
Yeah. And this is still, this is still a heated controversy today in terms of when is information public. Albeit with media today, information gets out there a lot quicker. Let's face it, this is the mid-1960s. We don't all have cell phones, and we don't, but the SEC still has not define precisely when information is public, because it still does continue to talk about reasonable dissemination and absorption by the investing public.
Yep, we have another question, third row.
Regarding the so-called misleading press release, didn't the Supreme Court subsequently hold in a case involving Ernst & Young that Scienter was a necessary element if someone was deceiving or manipulating under Rule 10b-5?
Yes, is the short answer to that question, in the sense that scienter intent, which is for civil violations defined as intent or reckless, and criminal, there's a bit more controversies in terms of that, but most circuits will hold that recklessness even suffices for scienter there. So yes, the securities law sort of moved on after the Texas Gulf Sulphur opinion, for sure.
But the Supreme Court has ducked what scienter means ever since. It's let each circuit decide for itself, and you got 12 different standards in 12 circuits. So I think it remains
Right.
confusing. The Supreme Court's ducking its duty. But
It'd be right for the Supreme Court to actually state what scienter would mean across the board then.
they could do better.
Absolutely.
Any other questions? We have about 5 more minutes for Q&A, so if anyone...
Could I?
Sure, yes.
I just wanted to make one observation about Adam's counting analogy, which I think is counting to 5 is everything. I mean, Adam and I have looked at the papers of all the justices, and in Chiarella, you can count to 5 for misappropriation. Now you got to count Stevens, who says, "I don't think I really want to decide," but Stevens votes for O'Hagan. He's the ones that's still around 14 years later. And just so talk about efficient markets. How did the New York Times reported Chiarella the case? Next day, front page, big news. Vincent Chiarella gets his picture in the New York Times. What struck me about the New York Times story is that it says flat out, after it reports the holding of Chiarella, it says, the SEC, the government, is planning to pursue future cases in insider, this is a paraphrase, future cases in insider trading will be on the misappropriation theory. Despite what Powell said about a narrow duty, the world, at least reflected in the New York Times, what the New York Times reporter was reporting, was that misappropriation was the lesson to take away from Chiarella, because there were 5 likely votes for it, even though it took 14 years. And remember, Chiarella was the first Supreme Court case on insider trading. Even after Texas Gulf Sulphur in '68, they went 12 more terms without taking up this.
And I think the first criminal case, Bob.
Sure, it was that too. But as Bob said, that was the first one that had been brought.
And the New York Times was right for once.
Well, so the SEC Historical Society has Frank Easterbrook's oral history and recollections. And one of the points that Frank Easterbrook made is that he was playing the long game with what he had tried to reframe as the misappropriation theory. And so it was a long game because it was 17 years later in the O'Hagan decision, as Adam took us through. So that the misappropriation.
I'm going to say you say you're playing the long game when you've lost the game.
But I read the history a little broader in the sense that Frank says he couldn't support
Right.
Yeah.
what the district court and the Second Circuit had done, and so he wasn't going to write. He was Deputy Solicitor General in charge of this area of the docket. He wasn't going to write a brief that went that way. So he goes out and does misappropriation. He gets 5 justices, almost except for the little messy situation that it wasn't argued to the jury.
Yeah.
and so that's why he has to play the long game, because the facts were against him.
Okay, so
I have one more question actually from YouTube, from one of the people live streaming.
sure, yes.
So, the SEC recently levied fines of $1.8 billion against a dozen or so financial firms, including 8 major Wall Street banks, for failing to police employees who routinely used encrypted messaging apps and other off-channel services on their personal phones to communicate with one another. Obviously, this could be a channel for insider tipping. Do you have any thoughts on this topic as it relates to insider trading, perhaps whether the SEC is adequately able to discover and read tips sent via encrypted messaging apps? In other words, would you agree that some insider tipping is likely occurring over private encrypted messaging services? If yes, how can this activity be prosecuted?
It's a shakedown by the SEC to collect money from large banks. It's kind of embarrassing, honestly. They should be going after people actually engaged in insider trading rather than putting out fishing nets and then extracting fines so they can report to Congress how much they've assessed in the way of fines. Bob might have a different view.
That was a rant, wasn't it?
Yes, I think so.
Short. I think yes, it's gonna happen. Yes, it is happening, and contrary to Adam, is wrong.
I would vote for wrong too. So, so I have. Let's see. So, well, I could. So Gary Cooper is worked on the case, and he is in the symposium. So Gary, would you raise? No.
He doesn't want to ask a question.
Okay.
I just wanted Bob Fisk to know that Gary Cooper was in the room, but Gary Cooper doesn't want to be acknowledged.
Okay. Then I won't. So
we are technically at time for a break.
So we can. During the break, I'm sure the panelists would be delighted to continue talking about this, probably well into the day. But I want to thank Marilyn for organizing and creating the vision for this symposium. Dean Brown and the Quinnipiac Law Review for all the hard work that you put into this. Bob Thompson and Adam Pritchard, who have been my friends for decades and who I just love talking about insider trading with. And most, Bob Fisk and Pete Eckenberry, that's for sharing with us your incredibly important recollections. It's very meaningful to professors who write about all of this and to students who read the case law to see the individuals behind that worked in the litigation. And so thank you. Thank you, Pete, and thank you, Bob Fisk, for sharing your recollections with all of us.
And thank you again. Thank you so much to the panelists. I now want to let everyone know that there are refreshments outside in the lobby, and we will be back and reconvene in 10 minutes.